Hello. Oh. Oh, you keep a camera open as well. Photo जाना. The main camera la. Oh, main camera open as well. The camera, main camera open. Open na ino. İki sistem on burada çalışma. Oraya bak. Ben there will be a short reference for the release and usually after the reference the matters have to be suspended. So right after the board matters are over, before the board rises, we'll have a short reference, so please ensure that all of us are present, please for the reference. We'll have the reference here before we go to the hearings. Here. Respondent number 2, return service. Video, né?
Hello.
Lordship, first of all, a very happy New Year to you.
Happy New Year to all of you.
Yes. Lordship, I would like to mention item number 4 and 5.
4 and 5.
Yes. Lordship, item number 4, the matter is before the cabinet for its decision. So, Lordship, I believe that the 3 weeks time will be granted to us.
And who is for the petitioner?
I'm for item number 5.
Okay. So in 4, no one. Okay.
The living council is actually here in the court.
He was there.
He was here. I saw him this morning.
Okay. I think whether have you informed the land council for the petition?
Yes, I have not informed, but he knows that I already filed my affidavit that the matter is before the cabinet. So that is within his knowledge, Lordship.
Okay. Miss
We should clear.
It's okay. Land council for the respondent number. You are in item 4.
Yes, madam.
So she is praying for, Ms. Sukri is praying for 3 weeks time.
Yes, sir.
Okay. Land council for the petitioner as well as Mr. Huh? You are the Khasi Santa. Land council for the petitioner and Ms. V. Sukri, land council for the respondent number 2 staff is prayed for by the land council for the respondent number 2. List is matter after 3 weeks.
Then, Your Lordship, in item number 5, I'm yet to receive the instructions. So, Lordship, I pray that another 3 weeks time may be granted to obtain the necessary instructions.
And so you have no objection, okay. You are for 8?
Yes, 8.
Or AG?
Yes.
AG is I respondent number?
8.
8?
8.
Okay.
As far as the part of the 8 is concerned, the magistrate approved the state because it's a matter of action. Unless they say no, they complies, we are not in position to.
Okay. But in any case, we are praying for 3 weeks time to file affidavit.
No, to obtain the instructions.
Obtain instructions. Okay. Hard miss, you are?
Obama, Lordship.
Okay.
For the petition.
Land council for the petitioner. And also Miss Sukri. Land council for respondent number
2 to 7.
who prays that she has yet to receive instruction from the respondent authority and prays for 3 weeks time. The prayer is not been objected to by the land council for the petitioner. Oh, sorry, before that, no? Mr. also appear on behalf of the respondent number 8, staff. The prayer made by Ms. Sukri has not been objected and not been objected to by the land council for the petitioner. Accordingly, the prayer is allowed. List is matter after 2 weeks. Okay.
May I please, my lord?
Yes.
Lordship, I beg to mention item number 9. I am for the respondent number 1 in this matter, Your Lordship. 3 weeks time may kindly be granted to me to obtain the necessary instruction, my lord.
Who is for, you are for the petition? Okay, you have no objection?
Yes.
Okay. Heard Mr. L. Likase, Sanctum, and Mr. Angami, Land Council for the respondent number 9.
One,
Who you are for one,
yes, ma'am.
one, who you are praying for how much time?
3 weeks time.
You prays for. It's still the matter of 3 weeks. The prayer made by the Land Council for the respondent number 1 has not been objected to by the Land Council for the petitioner. According to the prayer is allowed, list is made after 3 weeks.
Deeply obliged. Please, my lord. My lord,
Yes.
item number 7.
Yes,
Lordship state is preferring, I mean, the states preferring an appeal here in the case, so may it be listed after 3 weeks, Lord.
state made appeal with,
Yes. Against the judgment order passed.
Okay.
Yes.
you are for the petitioner,
Petitioner.
so you have no objection.
No objection.
So, Mr.
Yeah, I'm
Mr. Angami, Land Council for the
respondent
respondent
1 and 3, Lord.
1 and 3 submits that the state has made an appeal before, appeal against
Judgment and order dated 26/4/2022,
okay,
passed in WPC 229/2021.
21.
Yes.
So accordingly, pray for
3 weeks time, Lord.
2 weeks' time. Mr. Forte, Prosecco Forte, Land Council for the petitioner is also present. And he has no objection to the prayer made by the Land Council for the respondent number 1 and 3. So accordingly, the prayer is allowed. List is matter after 2 weeks,
Bless you, Lord.
3 weeks.
3 weeks, Lord.
Okay.
Please, Lordship, I beg to mention item number 8.
Item 8.
Yes, my lord, I have instructions to appear for the respondent number 2, 3, and 4. So I'm here to file my power and then I'm here to file my counter affidavit. So I may be given some time to file my affidavit as well as the vocal number.
To file affidavit.
To file affidavit
Okay.
as well as power.
You have no objection.
No objection, Your Lordship.
Okay. Miss
When Bonnie.
Land Council for the petitioner. I've also heard Mr.
And no comment, my lord,
and
no comment.
no comment. Land Council for Land Council appearing on behalf of the respondent number 2, 3, and 4. And prays for 3 weeks' time to file affidavit. To which the Land Council for the petitioner has no objection. Stop. Accordingly, the prayer is allowed. Stop. List this matter after 3 weeks. Okay.
Obliged, Lordship. Please, Lordship. Lordship, I beg to mention item number 11, Lordship.
Okay.
11, Lordship. Your Lordship, here, as for the office, the service report is still awaited, Your Lordship. So I pray that this matter will come after 2 weeks,
You are for?
for the petitioner, Lordship.
Okay.
I appeal
Land Council, Mr.
Medovero, Lordship.
Medovero, Land Council for the petitioner.
Appellant.
Oh, sorry.
Yes.
This is appeal, okay, appellate. Submits that the service report upon the respondent number 2 is still awaited. And prays that the matter may be listed after
2 weeks.
2 weeks. You are appearing on behalf?
Lordship.
For the state respondent.
Okay,
Public.
okay. Accordingly, prayer is allowed. List is matter after 2 weeks. Mr. Jimome, Land Council for this, sorry, Lana PP is also present. Okay,
Please, Lordship.
yes,
Item number 10. Lordship, here as per the office, not dated 17/11/2023. Service of notice upon respondent number 2 is still awaited, so let this matter be listed after 4 weeks, Lordship.
okay. Mr. Ejo,
Deputy Marshal on behalf.
okay, okay. W,
Deputy Marshal.
appearing on behalf of Mr. Ejo, Land Council for the appellant. Submits that the service report
Service of notice upon respondent.
Of notice upon respondent number 2, it is still awaited.
Yes, Lord.
And praise that, pray that this matter may be listed after
4 weeks.
4 weeks. The, you are for? Okay,
For the state.
okay, 4 weeks. Mr. Azimomi, Land Council for the state has no objection. Accordingly, the prayer is allowed. List is matter of the 4 weeks.
Much obliged.
Okay. Yes,
May it please your lordship.
Hmm.
Lordship, I would like to mention item 12.
12. 12,
12.
okay,
I am representing this respondent number 1 here. And my friend, Liz Momi, is representing the respondent number 2. I'll be filing my our Waklatnama today. So 1 week may be granted to me
okay,
to obtain instructions.
okay, Mr. Mr. You are long man,
Yes, sir.
okay. Land Council for the petitioner. Mr. Moimchen would appear on behalf of respondent number
1
1 and praise for 2 weeks. How much time?
1 week, 1 week time.
1 week time to file affidavit.
Yes.
Okay. And you are appearing,
I'm for respondent.
okay. Mr. Jimomi also present on behalf of respondent number 2. Yes, so is prayed for by the Land Council for the respondent number 1. List is matter after 1 week. Okay,
Oh, please.
For motion, item number 1.
yes, yes. My, use my.
Moving education under Article 2 of the
Yes,
Indian Constitution. The matter regarding this instant petition is that Lordship, I agree for non-consideration of my applications and representation to the post of beyond under the establishment of Deputy Commissioner Lake Nagaland and appointing the respondent number 3 respectively. Lordship, the petitioner is the descendants of the drilling plant from the village of Nagaland, which had given the land to the government of Nagaland for establishment of Deputy Commissioner Office and its peripheral areas and other government establishment. The government has taken over the state land with an oral commitment and conditions that appointment of grateful post shall be given to the landowner. And the petitioner, on coming to know that a post of beyond has been lined in the Department of Deputy Commissioner on retirement of one Mackay, who formerly served as beyond. However, the petitioner was astonished to learn from the official records of the department that the government has issued regularized order in respect of Western number 3, dated May 7th, May 2022. Lordship, aggrieved by the appointment of the respondent number 3, the petitioner had served a representation letter dated 24th March 2023 for approval of appointment of grateful. However, no formal reply was received from the domain of the Deputy Commissioner today. Hence, agreed by that the petitioner have no other alternate remedy than to approach this honorable court to seek justice.
the respondent number 3, whose service has been regularized, she was already in the service as a contingent or somewhere,
As fixed pay.
fixed pay. What is the rule for regularization of the service of the person who has been working as a fixed pay. Have you annexed the copy of the government notification? Where? Hmm? 27. This is regularization. She was already in service in that department. Hmm. So your claim is against the regular vacancy?
Which lies within the.
But you were not serving. You were not serving in the department. Okay. So whether earlier you have applied for the job. So whether they used to maintain the list of the person who applied, the landowner. How many landowners are there?
Township, I'm the only landowner.
Only landowner. Okay. You made an application earlier. Have you annexed that one?
It should be page 3.
When this application was made, submitted, page 23. Application of a post of due to the retirement. By the way, when the land was donated?
During the year 1973.
73. Since 73, no appointment.
There were no people from the deputy.
Where is the notification where it says that the landowners will be appointed?
Township, if you may kindly come to page number 3, which you all.
Yes. 2018.
3A.
3A. Yes. Yes, kindly let us read. Yes.
In other cases prior to 26 July 2025, 2005, and subsequently in setting up of administrative and headquarters on fully donated land, where a specific written or oral agreement exists providing for employment or other facility to the landowner. The claim of landowner for employment or other facility, department concerned shall refer the matter to the deputy commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. Written statements from the government officials of the department concerned, district administration, and the village functionaries present at the time of such written agreement should be taken by the deputy commissioner, should be referred with relevant documents and explanations to the department of the revenue for examination and approval. There is the notification.
Kindly read this B also.
It is also clarified that it is not the policy of the government to provide employment or their facility to the landowner. The employment or other facility of landowner is permitted by a variable and valid agreement is limited to the person first appointed as landowner in government service and does not entitle his descendants for further employment in other facilities on his retirement from service, vacates the post. After the appointed landowner.
Is limited to the person first appointed, yes. And then this retired person, whether he was the first appointed
No,
person.
he's not the descendant.
Okay,
The petitioner is the only descendant.
where do we find that you have donated the land?
Lordship, annexure A and A1, page number 21 and 22.
Yes.
Certificate issued by the Peg Village Council. I annex annexure A. This I'm going to like to read.
Yes.
This is to certify that Ms. Tito Wivilu, daughter of Mr. Neta Wivilu, is a bona fide citizen of Peg Village, and they are the landowner of the office of the Deputy Commissioner Office, premises, and other surroundings. Hence, the Peg Village Council strongly recommend Ms. Tito Wivilu to avail grateful post as and when vacancy for the rest, as they are the legal owner of the said office. The Peg Village Council further wishes success in the future.
So, no, whether the government has acknowledged that you are the land donor? Whether the government has acknowledged that you are the land donor? This is issued by village council. So whether the government has acknowledged, this is issued by the village council, but the government, whether the government also issued that you are the, acknowledge that you are the landowner in any way, in any document. This is village council. Donated for what? Deputy Commissioner Office. Entire village or you alone? Entire village has donated the land or you alone? And then till that, till today, you have never been provided any job, your family. So land was provided for no cost,
No compensation.
no compensation. That is why I'm asking whether the government has acknowledged that you are the land donor anyway. Whether the government has acknowledged that you are the land donor. No way. Okay, we'll issue notice already then. But you see, DC office, since 70, you have donated in the year 70, and you are claiming now, after 50 years. No idea. Anyway, but Miss Land Council for the petitioner. Stop, huh? Yes, government. So,
Let notice go, your lordship.
So she's claiming that she's the only one who has
Sole
donated.
landowner, that's what,
Hmm?
yes. She's claiming that she's the sole landowner, so
Hmm.
we'll have to see, your lordship.
Yes. Okay. And also Miss, an additional advocate general,
Senior government. advocate.
the Senate government advocate for the state, staff. Where issue notice. On the respondent. To show cause as to why a rule should not be issued. Is prayed for. And all. Why such or other order should not be passed as this court may deem it improper. Staff. The notice is made returnable by 4 weeks. Staff, since Ms.
Yes, Mary.
Has accepted notice on behalf of the respondent
1 and 2.
1 and 2, no formal notice need be issued. However, the petitioner shall serve extra copy of the petition to the landed senior government advocate within 2 days from today. The petitioner shall also take steps upon the respondent number 3 within 3 days from today by a registered post with AD staff. Any interim prayer also? No. Is there any interim prayer? No. Okay. Okay.
For motion, item number 2.
Yes.
This brief petition, I'm setting the appointment order of the respondent number 3 lodge on 2 grounds. Firstly, lodge, the appointment was made in violation of the constitutional scheme for public uprising lodge. It's in violation of the mandate under Article 14 and 16 lodge. There was no selection process, no invitations lodge. Secondly, lodge, in the year 2017 lodge, the state of Nagaland has formulated a policy for appointment of grade 4 employees lodge in district, in all the respective districts. As per the office memorandum 2017 lodge, it states that in district administration, appointment has to be made from the indigenous inhabitants lodge of that particular district.
Okay. Indigenous of that particular district or?
Yes, lodge. Yes.
Okay.
Now the issue pertains to the Wokha district lodge under the state of Nagaland lodge. And the petitioner here lodge, I'm an indigenous inhabitant of Wokha district. What has happened lodge, in addition to the violation of constitutional scheme lodge, the private respondent number 3 is not an indigenous inhabitant of Wokha district. Therefore, lodge, he cannot be appointed. And lodge, this is not a prayer that I should be appointed lodge. I have made application against a weapon post lodge. And the procedure clearly provides that there should be a recruitment board lodge. And the recruitment board should sit over all the applications submitted lodge. Now, such thing was not followed lodge in violation of the office memorandum of 2017. It is a simple prayer that lodge, the board should sit over the applications lodge. And since I'm also an applicant lodge, my application was not considered. And whereas a person was appointed who is not an indigenous inhabitant of a particular district, as well as there is a violation of the constitution scheme. That is my simple prayer, lodge.
So it's a fresh recruitment.
Yes, lodge.
Where is the appointment?
Page number 17. Page number 17.
Okay, yes, please, sir.
It is dated 16th of January 2023 lodge. Consequent upon the approval of government number so dated 13th of January 2023, the undermentioned is hereby appointed as grade 4 MTS, that is multi-tasking staff lordship. The grade 4 has been redesignated as MTS since 2021 lordship. In the establishment of so under this Department of Youth Resources and Sports Nagaland Kohima, in the pay level of so plus all other allowances as admissible under the rules and force from time to time with effect from the date of taking overcharge. This is the name of the private respondent number 3 and PRMS Board of Retired Employees against which vacancy appointment is made. Of course, this appointment is made against a vacant post, Lordship. The appointment shall be on probation for 2 years on completion.
This was approved by the government.
Yes, it has been.
On what basis the government used to appoint? Approved, I mean.
On the basis of the recommendation by the appointing authority, the government used to make the appointments, but this approval is in violation of the office memorandum, Lordship.
Where is the office memorandum?
Yes, Lordship. Page number 19,
Okay.
26 October 2017, Lordship.
Yes.
May I read it, Lordship?
Yes, please.
One, I'll start from the first paragraph. All direct recruitment vacancies arising in non-gazetted posts, including grade 3 and grade 4 posts under the establishment of deputy commissioners in district administration shall be filled up by the indigenous tribes of their respective district through a selection committee headed by the deputy commissioner and having 3 district level heads of the offices. An administrative officer, the regional employment officer or district employment officer, and the principal of senior lecturer of the local college to be nominated by the deputy commissioner. That is in respect of district administration, Lordship. Now I'm concerned with the second paragraph, Lordship. For the all district recruitments, vacancies in non-gazetted posts in a department, Lordship, except grade 4 posts, including such vacancies in the district offices of the department, shall be filled out by the following departmental recruitment board with the approval of the government. There was no departmental recruitment board, Lordship. Though there is an appointment of the government, Lordship, no such recruitment was conducted by the board, Lordship.
Well, departmental recruitment board
Yes, Lordship.
with the approval of the government.
Yes, Lordship.
So here in the present case, this department has forwarded to the government for approval.
Yes. But there was no departmental recruitment board constituted for this appointment. No, Lordship, it has also been reiterated in the letter stage, Lordship. If you Lordship, can you come to page 22?
Yes.
There is notification dated 17th of July 2018. May I read it, Lordship?
Yes, please.
In pursuance of these departments office memorandum number dated 26 October 2017, which I have just referred, Lordship, it is hereby reiterated that the appointment of grade 4 posts in the district shall be filled up by the respective indigenous inhabitants of the districts only.
Okay.
In this connection, all the departments are directed to submit a consolidated report on all the appointments made to grade 4 posts in the districts with effect from 26 October 2017 till date to this department latest by so and so. This instruction is issued with the direction of the cabinet. There is a cabinet approval also. Now,
Okay.
these are the standing government policy, Lordship, for appointment of grade 4 employees in the district administration as well as district offices in all respective districts. Even otherwise, Lordship, there was no selection process. So it is clearly in violation of the constitutional mandate, Lordship.
Yeah, yes, state. Hmm. Hmm? Notice. Please issue notice then.
Lordship.
Hmm. Okay. Mr.
More educated, Lordship.
Land Council for the petitioner and also S. Yeah. And government advocate. Hmm. You are representing? For the respondent number 1 and 2. Issue notice. Returnable by 4 weeks, no?
Lordship.
4 weeks, stop. Huh? Since since Ms. Swenson accepted notice on behalf of the respondent number 1 and 2, no formal notice need be issued to the said respondent. However, the petitioner shall furnish requisite extra copy to the land council for the respondent staff. The petitioner shall also take steps upon the private respondent number 3 within 3 days
Lordship.
from today by a registered post with AD staff So is there any,
There's no injury period also. The appointment was made in the year, 2023, January launch. So nearly a year has lapsed. Which made some, suggestions, time to make it launch.
Yeah.
So I'm left with pressing for interim.
no
It will
interim
be
period?
subject to the outcome of the petition.
Okay. Hmm. Cons- Okay. The appointment of the, just a minute, having regards to the contention made in the petition. And upon hearing the land counsel for the petitioner, the appointment of the private respondent number 3 for the post of
MTS was.
MTS. Which department?
Youth resource and sports.
In the youth and sports department.
Over.
What do we call it? Youth and sports department?
Youth resource and sports.
Okay. Youth
Youth resource and
or
sports.
youth resource and sports, government of Nagaland shall be subject to the outcome of this writ petition.
No.
Okay.
Much like.
For motion, item number 3.
Please, Your Lordship.
Yes.
Please, Your Lordship. Your Lordship, this writ petition raises the question as to whether the Dubai Customary Court can decide a case without disclosing necessary facts to a party in this regarding the principle of natural justice, Your Lordship. Your Lordship, the petitioner is presently residing in Saugata, and he has received a summons pursuant to a case filed against him by his brothers. Your Lordship, his brother here referred to respondent number 5 and 6, Your Lordship. Before the Dubai Customary Court, Dimapur, Nagaland, in respect of a family land dispute case, Your Lordship. However, Your Lordship, the petitioner was unaware of any dispute pertaining to a land between himself and his brothers, Your Lordship. As such, Your Lordship, an application was made to the Dubai Customary Court, Dimapur, Nagaland, for a copy of the complaint filed against him. The request was turned down. Thereafter, further application was made to the Deputy Commissioner. And the Deputy Commissioner has issued a direction to the head Dubai to provide a copy of the complaint. However, the same was not complied with, Your Lordship. The stand taken by the Dubai Customary Court was that they were under no obligation to provide a copy of the complaint to the petitioner prior to the hearing of the case against him, Your Lordship. This has put to the petitioner to a serious disadvantage and prejudice, Your Lordship, as he cannot reasonably be expected to meet the case against him in such circumstances, Your Lordship. Hence, Your Lordship, I'm finding this, seeking the intervention of this honorable for Your Lordship. Lordship, page 4, para 4, Your Lordship.
Page 4, para 4, what is that?
Your Lordship, the summons was received through WhatsApp
Okay.
on 14/11/23, which is a.
What is the procedure? Whether the respondent is entitled as per the procedure, the basis.
Dubai, as far as Your Lordship is concerned, they don't have any such procedure.
Okay.
But since there, we should be,
What they used to follow? No procedure.
as far as I'm concerned, they don't have any such procedure, not qualified.
Normally practice.
Normal procedure.
What is the normal practice here in the Dubasis? Who appear for the state? So because here the respondent has asked for the copy of the complaint against him so that he can file a written statement or reply. But then he has not been furnished despite a request. And probably you have made an application before the deputy commissioner also. And then a deputy commissioner also directed that the bus is under deputy commissioner,
Yes, Your Lordship.
is it?
Yes, Your Lordship. I have
Deputy
made an
commissioner
application-
also
Yes, my application at.
in the
page
body of the
number-
application said provide copy of the complaint to the applicant, but it was not provided, it appears. So what is the normal practice here? Whether the complaint is not being provided?
Lordship, I think there's not a formal procedure, but seems to be an interesting case, Lordship.
Hmm. So, what is now the status of the case there?
I have, thereafter I issued, receive another summons. The second summons, that is,
Fixing, next date,
it was.
when this, as per the second summon, the next date is fixed, next date of hearing. Second summon is page 19,
Page 19, yes, Your Lordship.
is this also
was
gone,
also-
4/12
Yes.
is December, and what happened thereafter?
Since the petitioner, he has undergone a procedural, heart surgery, he was unable to appear.
No,
So
no,
he
okay,
has engaged a counsel
Hmm.
and he has,
what is report, the report?
the medical report is at page.
No, no, not medical report, report of the council who appeared on 4th,
On the fourth,
4/12,
fourth, 12th.
because
yes.
next date was fixed on 4/12.
Yes, on the fifth, it was fixed on 15/12/2023.
Okay, what happened on that day?
On that day, the council appeared, but that day also they were not willing to furnish a copy of the complaint.
What they wanted, the buses, they want to settle the matter.
What they said was that, they cannot furnish a copy until there's a hearing has been completed.
So hearing not started.
No, no.
Whether ex parte hearing can also be done? No.
I'm apprehensive of that, Your Lordship.
Will issue notice then? Or Mr.
Abhi Sanat.
Land Council for the petitioner. The case of the petitioner is that who lodged complaint against you?
Respondent number 5 and 6, Your Lordship. We are my
Okay.
brothers, Your Lordship.
Okay. The respondent number 5 and 6, they are your blood brothers?
Yes, Your Lordship.
Oh. The case of the petitioner is that basing on the complaint made by the respondent number 5 and 6,
Yes, Your Lordship.
the what authority it is called?
It pertains to family land dispute case, it says, but
No, no, the authority who issued someone to you? Who issued someone, secretary?
no, the Dubashi customary court came out.
The was, just a minute, huh?
At Dubashi.
Secretary. It appears
Yeah.
secretary. Secretary Dobas's customary court
Yes, Your Lordship.
that issued someone to the petitioner. However, despite of making an application to furnish a copy of complaint against him and the direction issued by the Deputy Commissioner Dimapur to provide a copy of complaint to the petitioner, the Devasys, the Secretary Devasys Customary Court, Dimapur, has refused to furnish a copy of complaint to the petitioner. A copy of complaint, complaint in
this case-
dispute stroke poll case number DBC stroke case 1 stroke 2324 to the petitioner, thereby deliberately precluding the petitioner from contesting the case. Is that so?
Yes, Your Lordship.
Stop. Para. Para, issue notice. Returnable by 4 weeks. 4 weeks, stop. Since Mr. Ungam.
Yes.
Ungami accepted, you, senior government advocate. accepted notice on behalf of respondent number 1, 2. 1, 2,
One, Lordship, at this stage, 1 and 2, Lordship.
1 and 2.
Yes.
No
Yeah.
formal notice need be issued to the said respondent. However, the petitioner shall furnish, supply a requisite extra copy to the Learning Council for the state during the course of the day's staff. The petitioner shall also take steps upon the respondent number 3, 4, 5, and 6. Within 3 days from today
Yes.
by a registered post with ID card. Staff, huh? List is matter after 4 weeks.
Your Lordship, I have been an interim prayer that, I have a genuine apprehension that next party proceeding might be proceeded.
Okay. Having regard to the contention made in the petition as well as the document annexed and on perusal of the document annexed thereto. It is provided that the further proceeding of the case, the buses, no?
Yes, sir.
Further proceeding of the
DB's case number 01.
proceeding in dispute poll case number DBC stroke case 1 stroke 2324 before the buses customary court Dimapur,
Yes, your Lordship.
Dimapur, Nagaland shall remain stayed till further, till next date, till returnable date. Stop. Huh? Okay.
For admission, item number 6.
Yes.
May I read the Lordship?
Yes.
Subject, this interlocutory application is connected to the McAfee 7 of 2022 Lordship. While in the connected appeal Lordship, there is a inadvertent delay of 916 days, and which I have explained at paragraph number 7 Lordship, internal page number 6 of the application.
Worship, I filed my objection regarding the continuation of the.
You have not yet filed.
I filed my objection.
You have filed.
Lordship,
Okay. Just a minute.
I'm for respondent 1 and 2, Lordship.
1 and 2. 3. You have also filed objection. Already filed. Okay. Respondent number 3. And where is the? One and 2. Okay. Okay.
Lordship.
So,
Lordship, the impugned judgment
mm,
was rendered by the learned tribal on 19/11/2019, Lordship. And the same judgment was received by the insurance company.
You have also received the reply filed by
Yes, I have received.
objection filed,
I have
okay.
received, And
Do we need to fix for admission hearing or we'll have to go for hearing?
Lordship, I have sufficient grounds, whereby the Lordship may be pleased to condone the delay and the matter will fix for hearing. Lordship.
Yes.
I have already filed my preliminary objection, Lordship. Here, this appeal, Lordship, it does not suffice, Lordship. It's not mentioned in the first instance. This appeal should be dismissed at this condemnation stage, Lordship. I have clearly mentioned in my affidavit and position, Lordship, that I have the appeal, the grounds taken by the council, Lordship, that they received the judgment only on 2022. And it was on the grounds that the council did not communicate the order to them. That's the only ground. And regarding the COVID, Lordship, even if there's a COVID period, there's certain limitation that even though that has been condoned by the Honorable Apex Court, Lordship, even after that there is a lapse of a year, Lordship, and they are taking only on the ground that the judgment was not, the impending judgment was not communicated to the office, the head office, Lordship. So that cannot suffice in this instant case, Lordship. I have clearly mentioned in my statement, Lordship. And Lordship, I have also have the judgments regarding the limitation. I have also the Apex Court judgments and as well as the Honorable High Court, Lordship, that the court there should be a sufficient satisfaction justification for the delay, Lordship. However, they have not given any satisfactory justification regarding the delay in filing the appeal. So, Lordship, I pray that if this
What judgment you have?
Lordship, Lordship, the first is 2022 SCC online 478, Lordship.
Yes, what is it?
It's at para 30, Lordship.
Para
30.
30.
Lordship, married, Lordship.
Just a minute, sir. Yes.
This court in the case of Delhi, Dililha D. Songma in WPC so-and-so has dealt with the issue of delay and latches at para 22, 23, 24, which is reproduced here under. Para 22. The maximum vigilant bus non-dormitibus juris subvernum, which means that the law assists those who are vigilant with their rights and not those that slip thereupon, is very much applicable to the case of the petitioner as regard to the approach to the authority with the representation for the resurvey and measurement of land acquired, considering the fact that there is no gap of almost 27 years from the year of acquisition, which is 1983, to the year 2010, when the first representation was made. In the case of state of MP versus Nandlal Jaiswal, reported in 1986 for SEC 566. Para 24, the Honorable Supreme Court has held as follows. Para 24. Now it is settled that the power of the High Court to issue an appropriate writ under so-and-so is discretionary, and the High Court is in the exercise of a discretion, does not ordinarily assist the tradie and indolent of the acquaintances and the latrity. If there is inordinate delay on the part of the petitioner in filing the writ and such delay is not satisfactorily explained, the High Court may decline to intervene the ground relief in the exercise of the writ jurisdiction. Again on para 24. Again, in the case of the Chennai Metropolitan Water Supply and Sewer Board versus T.T. Murli Babu, held in para 16. Thus, the doctrine of delay and latches should not be lightly brushed aside. A writ court is required to weigh the explanation of what and the acceptability of the same. The court should bear in mind that in exercising an extraordinary and equitable jurisdiction, as a constitutional court, it has the duty to protect the right of the citizen, but simultaneously, it is to keep itself alive to the primary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court would not, under legal obligation, to scrutinize whether the lease at the belated stage should be entertained or not. Be be it noted, delay comes in a way of equity. In certain circumstances, delay and latches may not be fatal, but it must circumstances inordinate delay would only invite disaster for the litigants who knocks at the door of the court. Delay reflects inactivity and inaction of the part of the litigants. A litigant who has forgotten the basic norms, namely procrastination is the theft of time. And second law does not permit one to sleep and risk like a phoenix. Delay does not bring in hazards and cause injury to the list. So Lordship, here I also have another citation. So they have come only after 917 days, Lordship. 16, Lordship.
Okay.
Lordship, again, I may be allowed to place another citation, Lordship.
Yes.
Which is 2021 through SCC 317.
Yes. Para.
Para 17. Para 17 married, Lordship.
Para 17.
Yes, Lordship.
Yes.
But we do not think that the appellant can take the refuge under the above order in cognizance for extension of limitation in re what was extended by the above order of this court was only the period of limitation and not for the period up to which delay can be condoned in exercise of discretion conferred by the statute. The above order passed by this court was intended to be benefit vigilant litigants who were prevented due to the pandemic and the lockdown from initiating proceedings within the period of limitation prescribed by the general or special law. It is needless to point out that the law of limitation finds its roots into two Latin maxims, one of which is the vigilantibus et non domentibus juras subrendum, which means that the law will assist only those who are vigilant above their rights and not those who slept over them. So Lordship, overall this year they have been sleeping over their rights and now they are coming only at this late stage, Lordship. Lordship, I also have another citation which is 2010-8 SCC 685.
Okay. Two 2010.
Yes, Lordship. 2010-8 SCC. Para 30.
Yes.
Married, Lordship.
In
Union of India versus Tata Yogdawa Ltd, this court, while granting some latitude to the government in relation to continuation of delay, still held that there must be some way or attempt to explain the cause for such delay, and as there was no whisper to explain the legal problem occurred in filing the special leave petition, the application for continuation of delay was dismissed. Again, para 32, Lordship.
32.
Lordship, yes.
Hmm.
It must be kept in mind that whatever a law is enacted by the legislature, it is intended to be enforced in its proper perspective. It is in the equally settled principles of law that the provisions of a statute, including every word, have to be given full effect, keeping the legislative intent in mind in order to ensure that the projected object is achieved. In other words, no provision can be treated to have been enacted or purposelessly. Para 34.
Hmm.
Liberal construction of the expression sufficient cause is intended to advance substantial justice, which itself presupposes no negligence or inaction on the part of the applicants, to whom want of bona fide is imputable. There can be no instances where the court should condone the delay. Equally, there can be cases where the court must exercise its discretion against the applicant for the want of any of this ingredient, or where it does not reflect sufficient cause as understood in law. Again, para 35.
30?
35.
Okay.
The expression sufficient cause implies the presence of legal and adequate reasons. The word sufficient means adequate enough as much as to be necessary to answer the purpose intended. It embraces no more than what that which provides a penalty, which when done suffice to accomplish the purpose intended in the light of existing circumstances, and when viewed from the reasonable standard of practical and courteous men. The sufficient cause should be as it would persuade the court in exercise of its judicial discretion to create the delay as excusable one. These provisions given the court enough power and discretion to apply a law in a meaningful manner, while assuring that the purpose of enacting such law does not stand frustrated. Para 38.
38.
33. Above all, the principles which should control the exercise of judicial discretion vested in the court under these provisions. The explained delay should be clearly understood in the contradictions to ordinate unexplained delay. Delay is just one of the ingredients which has to be considered by the court. In addition to this, the court must also take into account the conduct of the parties' bona fide reasons for condonation of delay, and whether such delay could easily be avoided by the applicant acting with normal care and caution. The statutory provisions mandate that the application for condonation of delay and applications belatedly filed beyond the prescribed period of limitation for bringing the legal representatives on record should be rejected unless sufficient cause is shown for the condonation of delay. The larger benches as well as the equi benches of the court have consistently followed these principles and have either allowed or declined to condone the delay in filing such application. Thus, it is a requirement of the law that these applications cannot be allowed as a matter of right, and even in a routine manner. An application must essentially satisfy the above stated ingredients, then alone the court should be inclined to condone the delay in filing of such condemnations. So, Lordship, now in this modern technology, Lordship, the grounds taken by the appellant's lordship, they could have easily communicated to the main head office. However, they're just taking the excuse that receiving the judgment only on 2020, even after the lapse of 2 years, lordship. So I pray that this appeal may be dismissed.
Yes. Just your, okay, you have any submission?
Lordship, if the Lordship may kindly come to my affidavit in opposition for respondent 1 and 2.
Respondent 1 and 2.
Lordship. Therefore, Lordship.
Just a minute. Yes. Respondent number 3. Respondent number 3 is private.
Owner of the vehicle.
Owner of the vehicle. Okay. Yes. 1 and 2 is
Wife of the victim, Lordship.
okay. One is wife of the victim and 2 is?
2 is son.
Son. Okay.
Son of the.
1 and 2 are the claimants.
Okay.
So, Lordship, therefore, my affidavit in opposition.
Yes. Yes.
That with regard to the statement made in paragraph 6, 7, and 8 of the IR, the deponent respectfully stated the said statement cannot be accepted as showing sufficient cause for the containing the delay of 916 days. A perusal of the said paragraph plainly revealed that the appellant has taken a casual and negligent attitudes attitude in the matter because of which the delay occurred. This is the reason why delay of every day is required to be explained under the settled principle of law, Lordship. In the instant case, no such specific explanation has been made in the application other than a broad and a general statement. The statement in the paragraph 7 that the impugned judgment and order dated 19/11/2019 was submitted to the applicant by its panel counsel only on 02/05/2022. Due to the COVID pandemic in contrast and responsiveness, Lordship. No doubt, lockdown during the pandemic was imposed, but it did not continue for more than 2 years, Lordship. As it is sought to be projected in the IA, it is a fact that the lockdown began from March 2020 and starting from June 2022, phase unlock began nationwide and the court and public office also started functioning. There was sufficient time between November 2019 and March 2020, and starting from June 2022 or 2020 onwards, for panel lawyer to submit the impugned order, judgment and order 19/11/2019, but no explanation whatsoever has been rendered for the delay caused during the period when total lockdown was not in existence. Therefore, to say that the impugned judgment and order dated 19/11/2019 was submitted by the panel counsel only on 02/05/2022 due to the COVID pandemic, clearly it is a contrivance and an excuse to hide the negligence of the applicant, Lordship. So, Lordship, basing on that, this appeal may be dismissed, Lordship.
Yes, petitioner.
Lordship.
Yes.
As per the impugned judgment, Lordship, it is clear that the date of judgment is 19/11/2019, Lordship.
2019.
2019, 19th November 2019, Lordship. And we all know that in the lower, in the subordinate judicial Lordship, then there judgment order is not computerized or it is not published, Lordship. And it requires a substantial time, Lordship. However, Lordship, right after that comes the Christmas vacation, and from the year 2020, Lordship, the COVID started, Lordship. And the counsel for the insurer, Lordship, in the trial stage, Lordship, we could only obtain the certified true copy of the judgment and could forward it on 18/4/2022, which we have received at Dimapur office on 2nd of May 2022, Lordship. And Lordship,
just a minute, whether you have given a date, list of that?
Lordship, that's paragraph number 7 in my application, Lordship. Internal page number 6.
Yeah.
Lordship, if I may read.
Yes, please.
Lordship. The appellant has a divisional office in Nagaland. It has a regional office in Gauhati, Assam. Appellant counsel on receipt of the state's judgment could not forward the same to the appellant's divisional office situated at Dimapur in time due to the pandemic COVID-19. Appellant's divisional office on receipt of the judgment dated 19/11/2019 from its panel counsel based at Mokchung on 2/5/2022 forwarded the same along with the file to its regional office in Gauhati.
No, the appellant of the receipt of the judgment dated
Lordship.
from his, based on the motion. Okay, judgment, was, copy of judgment was received on 22.
Lordship, on 2/5/2022, Lordship. We have received it on 22, Lordship. Lordship, and forwarded the same along with the file to its regional office in Gauhati, Assam on 4/5/2022, Lordship. For approval, advice in preferring the appeal. The appellant's regional office on receipt of the entire file forwarded the file to its panel advocate at Gauhati for obtaining the legal opinion. The appellant's counsel based at Gauhati furnished the legal opinion on 19/5/2022 to the regional office. The appellant's regional office, office letter dated 20/5/2022, forwarded the file to the appellant's divisional office to prefer appeal before the Honorable Gauhati High Court Kohima bench. The appellant's divisional office on receipt of the entire claim file from the regional office forwarded the file to the panel counsel at Dimapur by letter so-and-so dated 26/5/2022 for preparation and filing of the appeal against the appeal dated so-and-so as advised by the regional office. However, the applicant's counsel was disposed for a month due to typhoid. The applicant's counsel prepared the appeal and collected interlocutory petitions and forwarded the same to the applicant's divisional office in Dimapur on 22/8/2022. The instant appeal was finally filed on 23/8/2022. Period of appeal being 90 days from the date of judgment, 19/11/2019, expired on 16/2/2020, Lordship. And thus there has been a delay of 916 days, Lordship.
So delay is 916 days.
Lordship. And the Honorable Apex Court, Lordship, in sumoto writ petition, Lordship, has extended the period of limitation to the COVID, and it has clearly stated that the period of limitation which is expired during the stage of COVID-19, it would start from 1/3/2022, Lordship. I have already placed a judgment before your Lordship. Lordship, it is sumoto writ petition 3 of 2020.
Yes. So this exclusion is from date?
Lordship, there were two writ petitions, and the latest is on miscellaneous application 665 of 2021, wherein it is stated at paragraph number 1, Lordship. Has your Lordship got it?
Yes.
Lordship. Paragraph 1, Lordship. In March 2020, this court took sumoto. Para 1, Lordship.
Para 1 of,
The
this is not a miscellaneous. In March, yes, okay.
Para 1. In March 2020, this court took sumoto cognizance of the difficulties that might be faced by the litigant in filing petitions, applications, suits, appeals, all quasi proceedings within the period of limitation prescribed under the general law of limitation or under any special law, both central and or state, due to the outbreak of COVID-19 pandemic. On 23/3/2020, this court directed the extension period of limitation in all the proceedings before courts, tribunals, including this court, with effect from 15/3/2020 till further orders. On 8/3/2021, the order dated 23/3/2020 was brought to an end, permitting the relaxation period of limitation between 15/3/2020 and 14/3/2021. While doing so, it was made clear that the period of limitation would start from 15/3/2021.
Now we are reading which paragraph?
Lordship, just finished with the paragraph 2, Lordship. Now paragraph 3, Lordship. Thereafter, due to a second surge in COVID-19 cases, the Supreme Court Advocates on Record Association intervened in the sumoto proceedings by filing miscellaneous application number 12, seeking restoration of the order dated 23/3/2020 relaxing limitation. The aforesaid miscellaneous application number 12 was disposed of by this court by order dated 23/9/2020, when this court extended the period of limitation in all the proceedings before the court's tribunal, including this court, with effect from 15/3/2020 till 2/10/2021. Paragraph 4. Present miscellaneous application has been filed by the Supreme Court Advocates on Record Association in the context of the spread of the new variant of COVID-19 and the drastic surge in the number of COVID cases across the country. Considering the next page, considering the prevailing conditions, the applicants are seeking the following. Lordship may skip the following paragraphs, and paragraph number 5, Lordship. Taking into consideration the arguments advanced by the learned counsel and the impact of the surge of the virus on public health and adversities faced by the litigants in prevailing conditions, we deem it appropriate to put the MA number so with the following directions. Number 1. Order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated 8/3/2021, 27/4/2021, and 23/9/2021, directed that the period of limitation from 15/3/2020 till 28/2/2022 shall be excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial or post-judicial proceedings. The para 2. Consequently, the balance of period of limitation remaining as of 3/10/2021, if any, shall become available with effect from 1/3/2022. In cases where the limitation could have expired during the period between 15/3/2020 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. Lordship. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply.
Means in the
In the event, Lordship, the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, the longer period shall apply. The period of limitation, Your Lordship, for filing the appeal is 90 days, Lordship. And if it is more than 90 days, then that particular date will apply, Lordship. So it is well covered, Lordship. And I don't think so, Lordship, if this honorable court condones the delay, it will prejudice the respondent number 3.
No, the excluding this COVID period, how many days, the delay of how many days?
Lordship, it comes to around.
Have you calculated
some days, Lordship.
Hmm?
If we deduct the COVID period, Lordship, and if we count from 1/3/2022, Lordship, it is 100 and something days, Lordship.
Where have you stated that?
Lordship, it is not stated over here. It is not stated in my application.
So total, how many days during COVID period it covers now?
Lordship, excluding the COVID period, Lordship. Lordship,
How many days?
Lordship, excluding the period of COVID, Lordship, it is coming 176 days.
No, COVID period, how many days is to be excluded during
Lordship,
this
as
COVID
per the-
period?
As per the judgment, Lordship.
As per the judgment?
As per the judgment, it is made clear in paragraph number 5, subpara 3, Lordship. I'm reading it again. In cases where the limitation would have expired during the period between 15/3/2020 28 to 2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a period of limitation of 90 days from 1/3/2022, Lordship. So my period of.
Which para you have?
Lordship, paragraph 5, subpara 3, Lordship. In cases where the limitation, has the Lordship got it? In cases where the limitation would have expired during the period between 15/3/2020 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. Lordship, my limitation will, as per this judgment, it starts from 1/3/2022, Lordship.
Limitation start from 1/3/2022.
2022.
No, the order was passed on 2019 only.
Lordship.
What about that period?
Lordship, order was passed in the year 2019 on 19th of November. 19th of November.
So this COVID period exclusion starts from 15/3/2020.
Lordship.
So what about the period till 15/3/2020?
Lordship, we have just received the judgment on 2022, Lordship.
Is it from the receipt of the judgment or?
Receipt of the judgment, Lordship.
Judgment received from where? You have received this?
From auction based council, Lordship.
No, this from council. Will that be counted? Whether the receipt of the judgment from the council will be starting point to be counted?
I have a next order, which is at my Annexure A, page 8, Lordship. Affidavit of
Because
Commissioner.
at the time of
Lordship,
pass.
the Honorable Lower Court has already given the direction to issue the order to serve the copy to all the councils, which I have also annexed, Lordship, which is order dated 19/11/19.
So on the date of judgment, the land council for the appellant was also present.
Yes, Lordship, if I may read, Lordship, it's at my annexure.
So what about that period? Period from the passing of judgment 19 and then till 15/3. Judgment or order of judgment was passed in the 2019-11. From which date it will be counted?
Lordship.
Will not the limitation period start running from the date when the order was passed or when the order was received by your land council? In
Yes,
the
my
mock
Lordship, from the date of judgment. Lordship.
Hmm?
From the date of judgment.
From the date of
From
judgment?
the date of judgment.
Yes, then from the date of judgment till 1911,
Lordship.
not 1911, so 15/3. Whatever this period, 15/3, because this Suomoto judgment, this starts from 15/3 to 28/2.
Yes, 15/3/2020 till 1st March 2022, Lordship.
So this period will be excluded.
This period will
What
be
about the period prior to that?
Lordship, as per my learned colleague's objection, Lordship, and the annexure, they have annexed page 8, saying that judgment order reserved on 18/11/19 pronounced today, Lordship. That is on 19/11/19, Lordship. But Lordship, it is nowhere stated that when the copy was made available with all the councils, with all the parties of the council.
Do you have the record that when the copy was made available to the land council for the appellant?
It's clearly stated extracted copy of the order issued to the parties, Lordship.
Where?
It's written in my annexure A, Lordship.
Just a minute, huh?
Yes, Lordship.
Affidavit,
Annexure A, page 8, Lordship. The type copy is at annexure B.
just a minute, huh?
Uh,
And a
page-
page,
Type copy is at page 9.
okay. Judgment order reserved on 18/11/19 pronounced today. Extra copy of the order issued to the parties. Issued. It said issued to the parties. So 19/11/19 already issued. So this also will be included from this 18 to
Lordship, from 19.
18/11/19 to
From 19/11/19 to 14/3.
3. So these need to be counted.
Lordship.
So how many days this comes? This also you need to count.
One 128 days, Lordship, deducting the period of limitation. That is 90 days.
So the period of 90 days expire prior to this order. Supreme Court's order in suo motu.
Lordship, COVID started, Lordship, his order was, if the order was passed in 1911, 2019. And as per the annexure is made available on 1911-19. And if it is order from 1911-19 also.
Just a minute. Huh?
Then we get.
Just a minute. Huh? Order was made on 1911.
1911-19.
19. Okay, so 90 days expired on?
Lordship,
Hmm? Eighteen two.
filed on 17th February.
90 days expired on 17.
17th February.
Okay, then from 18 February to 15, 14/3 is how many days?
From 18th. to 26.
26 days. Then this exclusion period is from 15/3/2022, 28 to 2020, and 22.
2022, 1st March 2022.
Oh, 1st March.
Yes.
Okay. So this is how many days excluded? March to 1st March 2022. How many, this will be how many days?
Almost roughly 2 years, 2 years plus.
2 years is, say, how many days would be? Okay, that will be excluded. Okay, then from 2nd March 2022 to till the filing, how many days?
From,
When it was filed?
Lordship, I think it was filed on 23/8/2022, Lordship.
So this consists how many days?
$173.
Plus 26, plus 26 days.
$199. Again, Lordship, that period of limitation, I mean, that 90 days again will be excluded.
Thereafter also, because 90 days already, your 90 days already expired earlier.
It expired, Lordship.
Hmm.
Total days of delay coming is 199 days.
Can you just place these days in accurate days, because now we have roughly counted.
Yes.
Can you just place in one paper?
Lordship.
Hmm?
Lordship.
To be the total, because you have not clarified here how many days of delay. So this one small
Lordship.
one page, okay, this list of date and the date to be included, to be excluded.
Lordship.
So that counting, submit one in one page
Lordship, by
written
Lordship, by filing an affidavit.
affidavit also.
Lordship.
Okay, file it today, tomorrow.
By tomorrow, Lordship.
Once you are received, I'll pass order.
Lordship.
Okay.
Lordship.
So if you have any, if the calculation, if you think that it's not correct one.
Lordship, my humble submission, I would like to rebut one submission made by London Council, Lordship. Lordship, even if they take the shelter of this, the COVID, the limitation which has come by the apex court.
Yes.
The apex court has clearly stated in this 2021 judgment, Lordship, that this extension of limitation is only for the vigilant litigants. So Lordship,
Right.
before the 90 days, they were like, before the COVID start, the 90 days already expired, Lordship. Even that, they have not pursued the matter, Lordship. So they were literally, they were like slipping over the rights. So I pray that if Lordship may kindly appreciate the judgment, this honorable apex court, Lordship.
We'll see into that also. Okay. You submit that one for correct calculation of the date of delay. This will be listed again or after receipt of your affidavit?
After the affidavit.
After the affidavit. Okay. This week itself?
Yes.
Okay. Heard. Now counsel for the appellant, Mr.
Bikramjit Devan.
Bikramjit. I have also heard Miss Kuikrolu. And then you are for respondent number
1 and 2, Lordship.
one, okay, Mr. I've also heard Mr. Mr.
Lucknow Form, Lordship.
Land Council for the respondent number 1 and 2, and Miss Mika, Land Council for the respondent number 3. Start. At this stage, Land Council for the appellant wants to file affidavit detailing the delay, days of delay in filing the appeal within 2 days, within 2 days,
Lordship.
affidavit within 2 days. Okay, from today. List is after, list is on Friday or what?
Lordship.
Okay, list is matter on Friday
Uh,
for further hearing.
Friday, I have some personal difficulties, Lordship, if on Thursday.
Thursday,
Thursday, Lordship. I'll be in Gauhati, Lordship. In Gauhati.
okay,
Lordship, if it is on Monday.
next Monday.
Monday.
Next Monday, I'll not be there again. And thereafter, of course, I'll be there on next Monday.
Okay, Lordship, duty.
Hmm?
Friday, Lordship.
Friday, okay. Hmm. For further hearing, huh? Hmm. Okay.
For for orders, item number 13.
Okay, so, okay, it's fine. Hmm. Yes, item 13. Okay. Hmm. Yes,
Lordship, as per the last order, passed on 14 November 2023, Lordship.
yes.
I was, the applicant was asked to take steps upon the respondent number 2 and 3, Lordship, by your Lordship. And I have already taken, Lordship.
You have taken steps, press steps. Notice issued. So return service still awaited.
Lordship, I am appearing for respondent number 1.
Okay, you are for respondent number 1. So this notice was. Two and 3. So no one appears on behalf of the respondent number 2 and 3. No one.
So far,
So far, they have.
So what do we do?
Lordship, let us wait for some more time, Lordship. If not, again, I have to take steps.
Okay. But Mr. V. Devnath, non-counsel for the appellant. And Mr. Nagy,
Lakne Pom, Lordship.
okay, non-counsel for the respondent number 1.
Lordship.
No. As per the office note, the office note dated 23/11/2023 reflected a notice was issued upon the respondent number 2 and 3 by a registered post with AD. However, the service report is still awaited. In view of the above, list is matter after
3 weeks.
after 3 weeks. Okay.
Plus, Lordship.
For orders, item number 14 and 15.
Fourteen and 15. No one appears on behalf of the parties when the matter was called for. Stop. The office note dated 8/9/2023 reflect that the service report upon the respondent number 1 to 10 is still awaited. Stop. This matter after 3 weeks. Okay. Hmm? Oh, yes.
Sorry,
Yes, yes.
why not this matter? I'm yet to receive instruction. I mean to say that,
You are for the petitioner,
yeah, I'm for the petition.
means appellant.
The notice has been issued,
Okay, yes, yes.
but still awaited.
Still awaited, yes. Okay. Now, Mr.
2 weeks may be allowed.
Okay, Elvin Joha, land counsel for the appellant. Hard, Mr. Han. So and so, land counsel for appellant. Stop. Huh? The office note dated 8/9/2023 indicates that notice was issued upon the respondent number 1 to 10 by a registered post with AD. However, the service report is still awaited. Stop. Huh? As prayed for by the land counsel for the appellant. List is matter after
2 weeks.
2 weeks. Okay.
And thereafter, if they don't, then we'll go for a fresh listing release.
Okay. Okay.
Obliged.
Okay. Hmm? Oh, no. Okay. Reference was to be made
Yes.
straight away, or I'll need to come back. Okay, that's fine. Again.
Someone called Joshua for the reference. No? For
You got very brave without finding.
Hi, Elvia.
Yeah.
For us to get used to the. So it was having a back off the board. Really, bar with the it actually in the Saudi job. So it was the value of the state workshop and then they were hard to get the way to do this. I'm going to call it, I'm tired of damaging this great news. Quite on my brother, so that's enough. Thank you so much.
Joshua knows better, I think. You just met the judge, no?
Yeah, I know brief information, just like reply to the portion of the Nalani, the actual. Mala Badali, but similar information, we should take note from there. The done of part, they forgot to do their part. So I'm just starting to wonder if we need to diagnose so that we don't get this. Zero number here. Last year, 1 minute reverse.
Well, please, Your Lordship.
Yes, please.
Course list for Monday, 15th of January 24 of the court. Before Honorable Mr. Justice Bodi Habong. Reference of dismiss of Ms. Cindy Tola, advocate. Order of reference. Number 1, miscellaneous reference 1K 24. Number 1, Ms. B. Sokori, additional advocate general, Nagaland. Number 2, Mr. Joshua Zakbi, general secretary, Gauhati High Court, Kohima Bench, Bar Association. Replied by Mr. Honorable Mr. Justice Bodi Habong. One after the reference, 1 minute silent. So.
Hello. Subject reference on the demise of Miss Sentitu Lalo Kumar advocate. My lord, we gather here to pay tribute to our esteemed colleague, late Miss Sentitu Lalo Kumar, who left for her heavenly abode on 2nd January 2024. Late Sentitu Lalo Kumar was a good human being and a good friend of mine. Her departure left a void in our lives. I, on behalf of the Advocate General Nagaland, the Additional Advocate General Nagaland, the Government Advocates Nagaland, and on my own behalf, express our deepest sorrow and offer our condolences to the bereaved family members. May the God of peace, that surpasses all understandings, give restful heart to the members of the bereaved family at this time of overwhelming grief.
Your Lordship, the reference on behalf of the High Court Bar Association, Kohima, upon the demise of our member late Ms. Cindy Tula. The members of the Gauhati High Court Bar Association, Kohima, are deeply shocked by the demise of our member late Cindy Tula, who passed away on 2nd January 2024 at Eden Hospital, Dimapur. Late Cindy Tula obtained her LLB degree in the year 2002 from the University Law College, Gauhati. She also obtained her LLM degree from Mumbai University in the year 2013. She was a member of the High Court Bar Association, an active member, and also an active practitioner. She served as legal consultant in the Directorate of School Education for several years, and from the year 2019, she had been serving as lecturer in Kohima Law College till her untimely demise. Late Cindy Tula was a woman of amiable nature with soft-spoken character. Her premature death is a great loss to the Bar Association and the legal fraternity in general. We pray that God will rest the departed soul in eternal peace and give solace to the bereaved family in this time of bereavement.
Ms. V. Sokri, Additional Advocate General, Government of Nagaland. Mr. Joshua Seki, General Secretary, Gauhati High Court, Kohima Bench, Bar Association. Demise of any member of bar or bench is always a loss to the legal fraternity. So today we have gathered here as one of our members of the bar, late Santi Tula, passed away on 2nd January 2024 at Eden Hospital, Dimapur. She was a member of the High Court Bar Association and was an active practitioner. She served as legal consultant in the Directorate of School Education for several years, and from the year 2019, serving as a lecturer in Kohima Law College till her untimely demise. Her premature death is a great loss to the Bar Association and the legal fraternity in general. May God rest the departed soul in eternal peace and give solace to the bereaved family. Now, we shall stand for 1 minute silence in honor of the departed soul. So, in honor of the departed soul, so rest of the court shall remain adjourned. Thank you.
Government law.